Hey guys, it's Zain. What's going on? What's up? I wanted to come at you today with a video about how important it is to really get along with opposing counsel or whoever you're dealing with regarding your claim, right? And I'm going to get into what I mean by that, but it's very essential that one learns to compromise and learns how to really negotiate, right? And I've said this before. Trials can be unpredictable, right? I personally believe that trials are the last resort. You go to trial because you can't really resolve something, right? You go to trial because you're not able to resolve something. You're not able to come to an agreement, right? And then this video, I'm leaning more towards the civil realm. Although in criminal law or criminal defense, you do want to try to negotiate or plea bargain or try to work something out before going to trial, obviously, right? Because a lot of times plea bargains happen even in the criminal realm. And then in the civil realm, you usually have settlements, which are kind of equivalent to plea bargains, right? In the civil realm, you're not going to trial in the civil realm, and then in the criminal realm, you're not going to trial because you're negotiating a plea bargain or you're actively pursuing a plea bargain instead of going to trial, because trial can be unpredictable. But the reason I wanted to say this was because it's not a good idea to always go to trial, right? And I understand your facts may differ, and sometimes it may be worthwhile for you to go to trial because you're not getting what you want, right? And you may have to pressure and go to trial, right? And there are a lot of trial lawyers, right? There's a lot of trial lawyers that will go to trial for you. I'm more of the opinion, I'm more so of the person that believes in settlement and trying to negotiate a settlement or negotiating a plea bargain. I personally believe in that because I like resolving things the way they are, right? And try to advocate for you because that's what you mostly learn in law school, and that's what one of the skills a lawyer is supposed to have, is to resolve cases successfully. And if trial can be avoided, try to avoid trial because trial is unpredictable. It costs a lot of money and all this and all that, right? And now that's not to say your lawyer shouldn't go to trial or you should tell your lawyer you don't have to go to trial, because you as a client, right, have the right to go to trial if you want to, right? You have the right to go to trial. Now, your lawyer may advise you or opine that it may not be worth going to trial because of whatever the facts that lawyer determines, but you do have, as a client, have an absolute right to go to trial. What I'm saying is, me personally, I try to resolve things without going to trial. And sometimes, right, you have to go to trial because you're not getting what you want. But if you are getting what you want, it's good to resolve things in the client's favor or your favor, right? It's always worthwhile to resolve things in the client's favor if possible. So, if you learn to negotiate, if you learn to corroborate your statements, if you learn to reach conclusions and reach settlements faster, reach plea bargains faster, and your client is okay with it, or the client essentially is okay with it, why not do that as opposed to go to trial, right? Because, again, trial is unpredictable. You could be shook going to trial, right? You could be shook going to trial. So, if something is negotiable, the facts line up, your client is happy, the client is happy, my client's happy, whoever I'm working out the deal for is happy, I always try to settle things and make the other party happy, right? Because in the future, you're going to be dealing with that other party again, right? You're going to be dealing with the prosecutor again. You might have that same insurance adjuster. So, if you learn to compromise, negotiate, you may have to give a leg or two up sometimes, but they're also given a leg or two up. That's why it's called negotiations. That's why it's called settlements. You're meeting in the middle sometimes, right? You can't negotiate if your demands are unreasonable. You can't negotiate with the prosecutor if the prosecutor is giving you unreasonable demands, unreasonable sentences. Then you have to take further action. But if you be reasonable and the other party comes at you reasonably, then why not reach a reasonable middle ground, right? So yeah, that's all I wanted to say today, guys. It's good to compromise. It's good to reach agreements. It's good to reach settlements, because trials are a lot of judicial efficiency goes into trials. It takes a lot of work, and usually it happens because both parties aren't able to reach a negotiation. So I advocate for settlements, negotiations, and compromising. Sometimes you have to give something up. Sometimes they have to give something up, right? And you want something that's beneficial to your client, because your client has the final say, right? I know my clients have the final say, and every client has the final say, right? So, yeah, that's it. If you guys have any questions, let me know. Comment, like, subscribe. All right, guys? Peace. I am out for today.